Come on back in, take your seats. We have a great next presentation because it is a panel. And I love panel discussions because there are so many voices that can lend expertise to one topic. And the topic for the next session is Assisted Outpatient Treatment Courts. Our next session has about how each program can be adapted to the LMHA's existing structure while still promoting healing and protecting the client's due process rights. The session will also explore the pathways that exist to take a case from the criminal justice system into an AOT court. Please join me in welcoming our panelists, who I will introduce now. You will first hear from Judge Oscar Kazen. He is the presiding judge of Bexar County Probate Court 1 and has served as an associate probate judge and a county court at law judge. Judge Kazen created and oversaw the implementation of the first fully operational civil AOT court in Texas, serving as the intersection between the law and treatment of individuals with serious mental illness in a 52-county area. This court has served as a national model, saving lives and lessening the suffering of those with serious mental illness by offering an alternative to hospitalization. Next, you'll hear from Judge Milton Mack. He is a state commissioner, a state administrator emeritus for Michigan, having served as state court administrator from 2015 to 2020 and as a probate judge from 1990 to 2015, including chief judge from 1998 to 2015. Judge Mack served as co-chair of the National Initiative Advisory Committee, which transitioned to the National Judicial Task Force to examine state courts' response to mental illness, where he served as chair of the Probate Work Group. After that, we'll hear from Daniela Chisolm. She is a contract attorney for Treatment and Advocacy Center, providing legal advice and guidance on the implementation of policy and state-specific legal standards for assisted outpatient treatment. Ms. Chisolm has spent 10 years in private practice at her law firm in El Paso, specializing as the attorney adlitem for mental health respondents in inpatient and outpatient court commitment hearings. And finally, we will hear from Professor Brian Shannon, a Horn Distinguished Professor at the Texas Tech University School of Law, and he serves as the university's NCAA Faculty Athletics Representative. He also is a board appointee for Star Care Specialty Health System, where he served for almost 30 years and twice served as chair. Professor Shannon is the author of multiple editions of the Guidebook, Texas Criminal Procedure, and The Offender with Mental Illness. He's also my former law professor. Let's welcome our panelists. All right, Judge Kazen.
Well, AOT in 13 minutes. Hello, goodbye. I'm Judge Kazen. Many of you have heard me speak before, and if you're here, you already know what AOT is. But is Dr. Keller still in the room? Okay, I'm going to make fun of him while he's not here. Who here watched The Water Boy with Adam Sandler? All right, about all of us. And there's a line in there where Colonel Sanders, the professor who was teaching biology, says, "Does anyone know where happiness comes from?" And Bobby Boucher says, "Golden rays of sunshine, Mama says." And he says, "No, it comes from the gluma almondata." And Bobby Boucher yells back, "No, you're wrong, Colonel Sanders. Mama's right." Well, right now, we got a loaded question. They said, how many of you believe you are in the justice, are justice-oriented? How many of you believe you are mental health-oriented? And how many of you believe you're both? It was a loaded question, and I'll tell you why. Those of us who raised our hands and said we're both got the "you're wrong." But the truth is, Colonel Sanders, you're wrong. Because he is correct. The system is set up for criminal justice and the system is set up for mental health. It's pretty hard to merge them. That is absolutely true. But what we do have are the people in this room and judges who do raise their hands and consider themselves both because we believe we are both. Because we believe we can make a difference in both systems. Because we want to come in and help a small category and group of individuals who are often unreachable or unhelpable with a tool that seems to work, AOT. So those of us and those of you who raised your hand and said, do you consider yourself both, do it again. And repeat after me, you wrong, Colonel Sanders. Because as people, we can be both, and that's what's required to drive the system to success, to change. Assisted outpatient treatment is one small piece of a very multicolored puzzle. And it is that one intersection along in the intercept model where we deal with individuals who haven't quite made it to criminal justice. Although Professor Shannon will talk to you about how it is we can incorporate those individuals. But AOT is the ability of a probate court, because in Texas, probate courts are the ones that are entrusted with the commitment process and how do you treat people who don't want to be treated. And I want to repeat that and echo that sentiment. Persons who don't want to be treated. Persons who don't want to get on the road to wellness, whether it's anosognosia, whether it's just an inherent belief that they're going to do it their way, or just they've been through the system so often that nothing you could throw at them works. And when we study that class of individuals, we see that they are the ones, that class of individual, are the ones who are eating the majority of our very limited resources. So is AOT the end all? No. Is AOT necessarily for individuals who have never been in the system before? No. Primarily, not exclusively, but primarily, it's for individuals with serious mental illness who have shown a consistent failure at treatment, who do not wish to participate in the program, and you can throw as many resources as you want at them. A month or two later, they'll be right back in the emergency room. And it turns out that if before you get them to the emergency room the third or fourth time, or have them arrested so that they wind up in jail, there's this one small tool. Again, something we need to reassess how we think about AOT. It is only a tool that seems to work in about 80% of the individuals nationwide who go through that type of supervision. I hate to use this term, but it's the easiest way to explain it to judges. It's like probation without probation for someone who's going through mental health treatment. But it's more than that. It's judges and a team of treatment and service individuals working together as a team to help people, and peers. And that would be, by the way, a model we need to work more towards in Texas since we're building this. And peers coming together to help somebody so that we can make wellness their habit as opposed to illness. And it turns out that if you have an individual who is on a court order, in some cases, in 80% of the cases, they actually listen. You know, there's an old kind of joke that I like to say, but it illustrates the point. So there's a car driving down in front of the San Antonio State Hospital, and it has a flat. And the guy's trying to change the tire, and he loses the 4 nuts that are that hold the tire on the lugs. And he's looking around in the grass, and behind the fence is a patient. And the patient yells out to him and says, hey, dude, why don't you get 1 nut from each of the other 3 tires and put it on that, and you'll have 3 nuts on each tire, you can make it home. The guy turns around, looks at him and says, wow, how'd such a smart guy like you wind up in a place like this? And he said, you know, I might be ill, but I'm not stupid. And it turns out that if you put somebody under the auspices of a treatment plan with an authority figure and a team, and that's the key, because we're in civil court, we don't have the gavel. We can't force people to do anything, but they know what a judge is. More importantly, if you can crack that window open under the court order just to keep them in your court long enough to realize that the team is on their side, your success goes through the roof. These are proven numbers across the country. We had studied some 10 or 15 years ago, we randomly picked 100 different individuals and put them through the treatment program. And Within the first 6 months of having them in the AOT, we cut their hospitalization something by 60%. During the year of, a year after the AOT, after we've established, this wellness pattern and a team, and they've bought into it, and they realize that there is another way, that went up to 80%. And when you think about that, what would it mean to your community if you took the top 5% of your individuals who were continually failing and got them to a point that they were at least 80% less likely to be in your emergency room for a year to 5 years out afterwards? It's huge. But what we're at fault, and what I'm here to tell you is this. We have made a mistake in Texas. I made a mistake in Texas when we first started the AOT. And that is, we came in with the law and we said, here's what we want to do. And many of the LMHAs went running, screaming away, because all of a sudden they saw a judge trying to tell them what to do, which isn't what AOT does. And all of a sudden they saw this cadre of individuals that they were now going to have to treat, which AOT does not. And all they could see was, how are we going to fund this thing? And what we should have started with was, and I should have gone to the LMHAs right up front and said, how can I be your tool? You don't work for me. We work for you. The judge may issue the order and the judge may have responsibilities to the order, but the AOT is a tool for the LMHA. I guarantee you that in every AOT that is developing in Texas, including my own, there is not a single person on my docket who would not have already been discharged from a hospital and sent to the LMHA in the first place. How many LMHA individuals do we have here? Raise your hands over here. Okay. When they get out of a hospital, what are they given? A referral. And where do they go? To you. There are thousands of people that get referred to you every year. You can't tell me, so for example, we help about 80 people and make a huge difference in our community financially and to those lives. Can you tell me that you can't find 80 people who are being discharged from a hospital that you know will maybe show up once, twice, and disappear? Raise your hands if all your people successfully go through their program. Not a single hand. Wow. Because what AOT is a tool for you, and that's what we need to change, that philosophy. We need to go to the LMHAs, and in some cases, I'm actually toying with this, I'm going to go to my LMHA and say, okay, to prove the fact that we're not costing you any money that will help you save money, you pick the next 80. You can be the applicant. You can work with my district attorney. We'll figure out how to get them into a court-ordered treatment plan. The only thing AOT is a fact or an act team with a judge helping individuals understand that they've got to do it. And it's not always strict medication, and it's not always drug-induced. And it is many times families getting involved and peers getting involved and caseworkers coming together with a court, some figure of authority that in 60 to 80% of the times people will listen to. I'm here because I'm sick, not because I'm stupid. It's a judge. Now that doesn't always work, but if you can open the window just 1 or 2 or 3 weeks, again, providers, how many here believe that the first 30 days after hospitalization is the most critical time to get them to start accepting services? Raise your hands. Every single one of you. And yet our greatest resistance in building AOT in Texas is the LMHAs sometimes. Not because they don't want to do it, because they view us as using them as our tool, the court's tool, when quite honestly, what we should have done from the very beginning is go to you and say, we're your tool. The judge doesn't step in and just say, you know what, you've got to give them drug treatment, and you've got to do this, and you've got to do that. I have no idea. I'm not the professional. You are. But I am a tool and a mechanism that with encouragement, with what's called the black robe effect, and that is, it's a judge sitting at the end of the table, and oh my God, it's the first judge in my life that's ever actually asked me, what can I do for you? And it makes a difference. So I challenge each of the LMHAs in here. Go to your judge that's starting an AOT program. Look at that judge and say, let's do a partnership. Let's test this thing. What if we identify for you the next 80 people who we know are going to fail the minute they get that little slip of paper that says show up to the LMHA? And let's work on them. Because I guarantee you I'll commit to that. And it may be a way of breaking the barrier in Texas as to how AOT works. It'll also teach judges to talk to the LMHA, and the LMHA to talk to judges, and judges to talk to doctors, and doctors to talk to judges, and doctors to talk to LMHAs. There are three people in this relationship that just don't talk to each other. But if we use each other as a team, as a tool, if judges recognize that we are a tool for the LMHA to bring people to a sense of health and wellness, we will all remember the one reason we're here. It's not the LMHA, it's not the judge, and it's not the physicians or the hospitals. It's the patient, and it's the ability to let them have wellness as their life instead of illness as their habit. So let's work on that in the next however long, and let's see if we can't build a better team with AOT in Texas. All right, that's AOT in 13 minutes.
Got it.
I'm eating into your time.
All right, add another minute to my time, please. Well, thank you for inviting me. You know, they say that an expert is someone from out of town with an opinion. So here I am, and I'm going to talk about Michigan and our experience. And I talk about the merry-go-round. And what I'm talking about is over the last 5 years, there have been 16,000 petitions for mental health treatment filed in Wayne County Probate Court for 9,000 people. 600 of those 9,000 people accounted for 34% of all the petitions for hospitalization that were filed. And what I can tell you about those 600 people is that they had a series of repeated short hospital stays without connection to treatment in the community, which meant we just go round and round and round. And I would suggest that all the resources expended were wasted. We accomplished nothing. But the good news is Michigan has changed its mental health code to change the way we intervene, in particular how soon we intervene. So we've opened the door to early intervention, and court-ordered treatment is now a viable alternative to hospitalization. Hospitalization is not required. This is a recommendation made in 2004 by Mental Health Commission, which the legislature finally adopted in 2018. So just have to be patient. What you'll know about notice about our new process is the decision that someone requires treatment does not require a finding that they present an imminent threat. It does not require a finding that there's a danger to self or others. It also creates a new process to secure outpatient treatment without hospitalization. And finally, we've introduced mediation in order to gain treatment adherence for persons who are mentally ill. So we have a new definition of person needing treatment. This is the basis of filing the petition for treatment. We have a greater focus on a person's capacity and risk of harm. We're not looking at their conduct. We're looking at their ability to make decisions about their illness. And we can order AOT without a showing of a prior hospitalization or incarceration. Many of the mental health codes across the country say you have to have 2 prior hospitalizations or 2 prior incarcerations before you can order AOT, which strikes me as odd because maybe it's just me, but I think AOT is less intrusive than hospitalization. Anyway, but a probate judge can now order outpatient treatment in any case that's filed in the probate court now. Now this is one of our newer definitions. This is 401A, which deals with your more traditional danger of self or others. Has been changed as someone with a mental illness who can be expected in the near future to harm someone, and they've engaged in an act that supports that. That act does not have to be a recent act. In fact, we have a couple of Court of Appeals decisions in Michigan. In this particular case, they said an act that occurred years earlier can be the act that supports going forward. And a second case where the doctor said, look, past history is more predictive of future behavior than current statements. So as a probate judge, I'm sure Judge Kaken would agree, we're pretty good at finding facts, but not necessarily predicting the future. So we look at prior history. But really the most important change we made is in 401C. This to me is really is the most important thing, because it gets us closer to a standard of you have someone who has a mental illness who doesn't understand the need for treatment and therefore refuses treatment, and this creates a risk of harm. So I'm not going to read this whole thing to you. Instead, I'm going to give you the Cliff Notes version. And these are the questions that the court has to ask in order to decide whether to order treatment. Number one, does the person have a mental illness? Is the person's judgment impaired? And does that impairment cause a lack of understanding of the need for treatment? But even further, is the person unwilling to engage in voluntary treatment? You may not understand your need for treatment, but if you're willing to engage in treatment voluntarily, then you don't meet the criteria. But so if you don't understand your need for treatment and you're not willing to engage in treatment, and that treatment is found to be necessary to prevent a relapse or harmful deterioration, and that results in a substantial risk of significant physical or mental harm, then you are a person requiring treatment. And we have one Court of Appeals case now which has interpreted that. And in this case, the Court of Appeals held that the doctor's testimony that untreated schizophrenia increased the risk of dementia, drug abuse, suicide, and further decompensation, including delusions and paranoia, was sufficient to order involuntary treatment. And really what I found most interesting about this opinion, the doctor testified at the hearing that as of the hearing date, this individual was not at risk of harm to himself or others as of the day of the hearing. However, he did not understand his need for treatment. He could be expected to cease treatment in 3 to 6 months, and then he would begin to deteriorate, and then he'd begin to be exposed to all these risks that were previously described. So this is a standard that permits earlier intervention. You don't have to wait for crisis. I've sometimes compared it to a train going down the tracks and the bridge is out. So what are we going to do? Radio the engineer or park ambulances at the bottom of the ravine? Well, historically, we've just parked ambulances at the bottom of the ravine. I think we need to intervene early in order to make sure that someone has an opportunity to recover, because you know that waiting damages resiliency. So it's also important to remember that this standard for intervention is a standard relating to ordering treatment, not hospitalization. It is the severity of the illness and the immediacy of the risk of harm that governs whether hospitalization or outpatient treatment is necessary. As Dr. Keller mentioned, if you treat heart disease, we don't hospitalize everyone with heart disease, but we don't ignore them either. We provide outpatient treatment until they need to be inpatient. So the important thing here is the intervention can take place before a crisis, and the court can just proceed with assisted outpatient treatment. There's no special provision, like many statutes across the country. If you're a person needing treatment, we can order AOT. Review hearings are not required. We can do those things. In Genesee County, where Flint is located, they've got about 400 people on AOT, but they find that 90% of them are compliant. Another 5% become compliant with some conversation, and then another 5% they might have to bring in the judge. And the judge is very effective at making them feel guilty for hurting their feelings for not participating. So when I teach law enforcement as part of the CIT training in terms of how probate's involved, and so I go over this with them. I say, here's the old standard for intervention. There's an immediate risk of harm to self or others. That's not the standard in Michigan anymore. The question is there a substantial risk of harm due to impaired judgment? And law enforcement deals with impaired judgment all the time. So we also created a new pathway to care. So the first is your traditional method of starting out the hospital, but the second is AOT only. We bypass the hospital, skip it entirely. And what happens there, a family member or anybody else can file a petition with the probate court, a bare petition, no attachments, that says, my son has a mental illness, I'm worried he's decompensating, harm is going to come, I want outpatient treatment. And what we do is we set up a hearing in 28 days. And then it's up to the petitioner to get an examination of the individual. If they refuse, we can order the individual taken in for an examination, but they're not hospitalized. The challenge, though, is we need a psychiatrist to testify. And we're trying to get that change in the law right now. But if you're a community treatment provider and you have a client who is beginning to decompensate, you don't have to wait. You probably have a psychiatrist on staff that you can employ to provide the testimony you need to get the AOT. But one of the things we've done is by creating that little window of opportunity between filing and the 28th day for the hearing, is we have mediation. So these cases are automatically sent to mediation. We have a community mediator who's trained in this area. Of the first 5 cases that were sent, in 3 of them, the patient agreed to a treatment plan. We know one thing, if you want treatment engagement, you want the patient to be a part of the treatment team. In fact, in Genesee County, when they give the patient the form for what the treatment team looks like, they inform the patient, you're on the treatment team. So, because you want treatment engagement for longer term recovery. But maybe before I get into competency, one of the challenges we're facing is it's a cultural change. For 50 years, we've gone forward on danger to self or others. For 50 years, we've treated self-determination like the illness gets to make the decisions about whether someone gets treatment. Well, that's changed. And it's hard to get everyone on board, and it's a challenge to get all the community operators on board too. But we are working on that, but it will take a community. But I want to just cover briefly, we're seeing a rise in misdemeanors going to the forensic center. I know you have too. And so our forensic center has said, you know what, we'll go ahead and do the competency examination, but we're not going to do criminal responsibility. So basically, we're shutting that operation down. But we have a bill to provide that if someone is charged with a misdemeanor, they appear to have a mental illness, that they get moved into the civil side, get an AOT, and drop the criminal charges. And what's interesting is the prosecutors got together with us, and they are the prime sponsor of the bill. And NAMI is on board. The Protection and Advocacy Group is on board. We have everyone on board. So I am going to stop there because I know you've got lots of questions.
Thank you.
Hi, good afternoon, everyone. I'm very, very happy to be here with you all today. If you notice, there's a little bit of an age difference on the panel between me and the other panel members. I just moved out of being a baby lawyer. After 10 years, they kind of cut us some slack and we get to move out of the baby lawyer range. But I'm just happy to be part of this very distinguished panel. I had a chance to meet Judge Kazen a few weeks ago at the AOT Symposium, and now learning from both of these gentlemen here today. Just very, very excited. So I do twofold. I work as the attorney ad litem for the participants in the El Paso AOT program. And I also work with the Treatment Advocacy Center, helping to implement new AOT programs across the country, and also to provide technical assistance to programs that are already in existence. So I just want to share a little bit on both of those aspects today. with you all. And when we talk about AOT and just following up with Judge Kazen, we're really looking at a shift in perspective. And what I mean by that is that we're looking at, as lawyers, we're used to being adversarial, very inflexible, and we're looking at a new way of interacting with each other, with our local mental health authority and all of the stakeholders at the table. How can we look at this as a collaborative effort so that we're working together for a common goal? And I'll say that I found myself in the AOT journey not really by choice. I was voluntold by my probate judge I was going to be the attorney ad litem. And to be quite honest, I was a little bit resistant. And by a little bit, I mean a lot resistant. Because like many of you, I've saw many of the same clients over and over again in the mental health system in the revolving door. And I was discouraged. I didn't think this program was going to be any different. I think I just saw more obstacles for my clients to have to overcome. But fortunately, the program worked on me in many, many ways, and I'm able to be here today to share some of those experiences with you and how I changed. I've seen my legal partners change, my judge evolve, and most importantly, some of the most difficult cases in my community have now become extreme success stories. And a really important segue into how does it become successful is really taking each of the legal partners and maintaining our individual roles, but also finding a way to work together. It's very important that I stay in my lane as the attorney ad litem. I make sure the due process rights are protected for my client. The judge maintains their role when they're hearing evidence on a case. The attorney for the petitioner is making sure that everything is brought to the court's attention. And at the same time, our interactions together can be kind, they can be compassionate, they can be patient, they can be collaborative effort. And that's the way that we start to take some of these barriers that we're all aware of and obstacles, and we start to move through them together as a team, but not at the cost of the patient's due process rights, not at the cost of the integrity of the legal system. And there is a way to create a dream team. It doesn't happen necessarily overnight, but we start to find a stream of characteristics that allow us to create an ideal team of individuals that are already in our mental health community, and we start to pull them together to the table so that we can have a conversation with that dream team to really put these concepts into action. It's now at the point where we can't just gain knowledge any longer and take that home. We've got to take actionable steps. And so again, we're just moving away from that adversarial system. And I've got my colleague here, I call him a prosecutor, but he's the county attorney, and we've known each other for some time. And we did criminal defense cases together for quite some time on opposing sides. And we found ourselves in the mental health system. We had to drop the way that we used to advocate for our clients, or for my client and for his client as well, and find a way to be able to communicate and talk with each other. And now we have a really, really strong relationship as opposing counsel where we can problem solve together. And it's just something I didn't think was possible we'd have in the courtroom as well. We do have a friendship that allows us to help our clients. And one is that key word is communication. This requires a lot of talking amongst the legal partners, including the judge. Oftentimes I'll stay after, or we'll all stay after we have our weekly check-ins, and we'll brainstorm together, how can we make our program better? What are our barriers? And we start to listen and learn each other's language so that we know, okay, this is where they're coming from. We're all in the same, we're all looking for the same thing, is to help this client, help this participant in the program, to empower them, to help them be engaged in their own treatment. And again, this is, I mean, as far as the legal aspect of things, it's a very important as a defense attorney. Before I was a defense attorney for mental health, I did criminal defense. And so my father is a criminal defense attorney. It's very important to me that my clients' rights are protected. And that means making sure we're getting notice, making sure they have a right to come to the hearing, all of those things being done. And what I found with this collaborative effort and moving away from adversarial is it's not all the weight falling on just the attorney ad litem or the public defender to make sure these rights are being protected, but we're spreading the weight. Now the judge is taking a look at things, the prosecutor is invested, and we're all working together to make sure that this person's rights are being protected. So a lot of time, instead of looking at it as a constriction or restraint on this person's due process rights, we're actually finding a way to expand and have more eyes making sure that this process is flowing properly for the client. And Well, I wish Judge Kazen had more time to talk. He's a very involved judge. There is a difference between a passive and an involved judge in AOT. Both work. If you have the opportunity to have a judge that's engaged in the AOT process, you are just, it's going to be such an expansion of the program. Judge Kazen and also my judge in El Paso, Judge Joseph Strelitz, are extremely involved judges. They work with the clients, meeting with them weekly. They find out information about family members, what are their likes. We have a book club even in our El Paso AOT program. And that development and creation of the relationship between the judge and the participant is just something even that is unparalleled that I've been able to see. Some of my most difficult clients, once they bond with the judge, they look forward to coming to the round table or the status hearings every week. So it's an opportunity also to change the perspective on the judicial system for these mental health clients. A lot of the crossover is mental health and criminal justice, and we now have a fresh opportunity to show this person we have a kind, compassionate court that wants to help you, that wants to empower you, that wants to see you get well and stay in the community. So I hope that if you all have any questions about an involved judge, you'll approach Judge Kazen afterwards, because he's got tons of ideas and ways that he approaches the clients that are just wonderful to utilize. And the dream team is possible. I know we've spoke a lot about, and we know the barriers are the workforce issues, people being burnt out, the system just feeling overwhelming. But I'll tell you, if we just start looking at characteristics of people who are already in our mental health system, who are already those providers that are standing out, and we start to approach them, support them, and bring them to the table, little by little, piece by piece, we can build a dream team. We can have a successful program that does empower our clients. And I think that really stems from whether I'm in the courtroom or outside the courtroom. For example, with my opposing counsel, Michael, I show him respect, I show him compassion, I listen. As much as it's very hard for lawyers to listen, I do my very best. And then we have a shared desire for our program to succeed, which is very, very, very important. And I have so many things I wish I could share with you about the AOT program and just how many success stories I've had. I'll just pick two of them. Our program is young. It's just about 2 years old. We had our first 2 clients that were in the program were some of the most difficult clients that I've seen out in and out of the revolving door for the past 10 years. And when they came into the program, I thought, there's no way. This isn't going to work. These cases are too hard. And both of these individuals just graduated a few weeks back. They have gained employment. They've stayed out of the mental health system. They haven't been in the criminal justice system. They've repaired relationship with their family members. They've done volunteer work. And now both of them are applying for a peer support specialist certification program. So they can now come back to our program and assist others that are just beginning in our program. So the program works. It's a wonderful tool, like Judge Kazen says. It's a tool that we can utilize to bridge the gap between our judicial system and our mental health system. And I'm going to just put this point out there again, that we come to these conferences, we learn so much new knowledge, we hear from such wonderful speakers, but now more than ever, we need to put our knowledge into action. We need to take what we learned today back to our communities, and we need to do something about the problems that we're talking about, whether it's talking to a judge about an AOT program or adding peer support specialists into the conversation. I just encourage us to go home and to look at the mental health, I guess the whole thing as a spectrum. Instead of looking at it as such a polarized system, if we can start to see everything as a spectrum of possibilities, we look at it as a possibility for a collaborative effort. And then we hold each other accountable. We hold ourselves accountable for coming to these conferences and taking the information home, doing something about it. We hold our peers accountable, and we also hold the community accountable. It's time for us to bring everything together and to go home and to make a difference. So thank you so much for your time. I appreciate it. I'm looking forward to any questions. And I'll go ahead and turn it over to Professor Shannon.
Like 7 feet tall. Ducking doesn't matter for you, my friend.
Good afternoon. Even though tech is in my employer's name, I'm so glad you were here to do that because I do not have those special skills. I want to talk a little bit on some opportunities that we have currently under Texas law that would permit the opportunity to transition from the criminal justice system and into AOT. It's happening in a few places. Bexar County with Judge Kazen, the program in El Paso that Daniela talked about, they're about to try to expand into the criminal area. So it's not broadly adopted yet, but it's possible. And at Texas Tech, our motto is from here it's possible. So for the next 10 or 12 minutes, and I assure you my students would love it if my classes were only 10 or 12 minutes, I want to talk about some of the tools that we have available under Texas law, which I like to describe as pathways to AOT from the Texas criminal justice system. And you'll see a slide in a little bit. I helped do a booklet with the Treatment Advocacy Center where Daniela works, and Judge Kazen helped with it as well, where we've got a chapter in there where we explore that more about some of these options I'm going to describe. So there are a number of different pathways, some you're familiar with. The first really is at Intercept 1, and I'm glad Dr. Keller talked about Intercept 0 because I'm moving into 1, 2, and 3. At Intercept 1 with law enforcement, we know that officers have the authority to make a choice if they believe that there's a person with mental illness who meets the criteria, probable cause to believe that the person has a mental illness, is dangerous to self or others, or deteriorating, where they could do a warrantless emergency detention, and then we're not going to criminal justice at all if we have the facilities available and the opportunity for the emergency detention path. So pre-arrest diversion, we're pretty familiar with that. That's happening in a lot of our communities. Post-arrest diversion, I'm going to talk about both pre-booking, but mostly I'll talk about post-booking. So at the next levels, when we're thinking about, all right, the officer's not made the decision to divert, not made the decision to proceed on an emergency detention, but instead to make an arrest. Harris County, and where are Harris County folks today, has developed a process, and if it's been replicated elsewhere, I'm not yet aware of it, but they have a shared booking desk that's staffed by both the local mental health authority for Harris County as well as the regular criminal justice center folks to do a screening right then and make a decision, can we divert this individual rather than go in and go forward with booking? So another opportunity that's available. But I want to spend most of my time talking about post-booking diversion. So arrest is made, the person's booked into the jail. You're familiar now with the changes that were enacted to 1622 2 sessions ago that added 1622C5. So we've got some initial determinations, reviews, interviews of the person to identify whether he or she is a person with mental illness or intellectual disabilities, is in need of treatment, and if there is potentially a need to queue up a full competency process. That 1622 report goes back to the court, and the court then has a number of options under 1622 C1 through 5. We added subsection 5 2 sessions ago, so that even if charges are pending, and a decision could be made to divert to outpatient civil commitment while the charges are pending. And so that's one post-booking option or a pathway to AOT. Another is a dismissal of certain charges and diversion to AOT. And let me talk about those in more detail. Under 1622C5, question is, does the offense involve an act, attempt, or threat of serious bodily injury to another person? If not, then this is an option. Notice this doesn't say misdemeanors or felonies. Those of you who are involved in the criminal justice system, you're probably thinking, oh yeah, there are some felonies that don't involve an act, attempt, threat, or of serious bodily injury to another person. So it's a possibility in these non-violent settings to be able to dismiss the case in effect. Well, you're not dismissing the case, but you're effectively abating the criminal case. The person's going to be put on bail, and then in effect the matter is going to be transferred to the court with probate jurisdiction to review whether or not a mental health outpatient commitment or AOT order is available. If the person's then successful through the AOT process, it comes back to the court, and the court can dismiss the criminal charges at that point. A couple of issues come up. One, for this to work, there's got to be communication and cooperation across various spectrums. You heard Judge Kazen talking about getting the doctors to talk to the judges, to talk to the mental health authority. Well, here sometimes we've got to get different judges talking to each other, right? Because often we're talking about two courts. In Bexar County, we've got a statutory probate court, two of them. We also have the criminal courts. And under Texas law, those criminal courts would not have probate jurisdiction because there's a statutory probate court. So for this kind of handoff, the two courts have to work together. We also have differing states' attorneys. We've got a prosecuting attorney for the criminal case, but we're going to have a county attorney, or in law book, it's the civil division of the criminal district attorney's office, but a different office that's got the responsibility to deal with the mental health commitment. So that's going to require cooperation. We may have the defense lawyer, but also an adlitem attorney. And so these are not impossible to overcome, but it takes communication, coordination, a really good court coordinator who can keep up with all of this to try and keep things on track to help make this work. Now, in counties that don't have a statutory probate court, there's a possibility for some of these matters that it could be one court, but two different dockets. So take, for example, a county that doesn't have a statutory probate court, which is most of them, but let's say they have a statutory court at law. Well, the criminal case might be in front of that statutory court at law judge, but that judge also has probate jurisdiction. So it's possible there could be a shift of docket as opposed to a transfer, in effect, to a different court. So that's an administrative challenge, but it can be overcome for this program to work. Secondly, the statute talks in terms about somebody being successful in the AOT program. We'll pause for a minute and think about the timing involved with respect to civil mental health commitments, outpatient commitments under Texas law. The initial commitment can be for either 45 or 90 days. Well, the programs that you're hearing described for graduation and success, it's usually not 45 or 90 days. It's going to be somewhat longer. So there needs to be some understanding between the criminal court judge, the prosecuting attorney, the court with probate jurisdiction, if we're talking about two courts, that success, it might take 18 months or 2 years. And so there should be some expectation or not a surprise if after that initial 45 or 90-day civil commitment hearing, an extended outpatient commitment hearing and order is entered as well. Because we want to make sure this is a success and somebody continuing to be part of that program. Alternatively, we could have what I prefer to call non-statutory diversion. For example, under 46B, even if there's been a competency, lack of competency finding, or at any point in the criminal process under 46B, there's the ability for the state to dismiss the case. And you then turn to 46B 151 that permits the opportunity for a civil commitment once charges are no longer pending. And so again, it'd be a transfer to a court with probate jurisdiction if you've got a two-court type county or a switch of dockets potentially in court counties that don't have a statutory probate court. I've seen this work successfully without AOT where, say, somebody has gotten treatment in the jail while charges are pending, resumed medication. There's a work between criminal defense lawyer and the local mental health authority where they can come up with an agreed treatment plan to offer as part of a plea offer with the state, and the prosecutors agree, and we've got a dismissal in exchange for an agreed treatment plan. Well, there's no real teeth to that if the person then drops from that. So a different approach or option is, if there's an active AOT program, is you add the layer of the black robe effect of the court being involved in that. So that's another area that's there. Some additional options where AOT theoretically could be a tool, and it's been more than theory in Bexar County, is possible diversion AOT for a defendant who's subject to an order for competency restoration services but is still in the jail awaiting a placement. There might be consideration given for the possibility of a dismissal and then a move to the AOT court's docket. A possible diversion if a defendant's unrestorable, where there isn't an option for a competency restoration order, but only options for hospitalization or outpatient commitment. Some individuals may be good candidates for AOT. Or somebody who might be doing well in an OCR or JBCR competency restoration program, where a decision is made, hey, they're doing pretty well, we can at this point dismiss, divert to AOT. So there's an array of options that are there. I think AOT has great potential. We've got to expand its availability and buy-in and encourage greater use. And there's a link to the free guide that treatment advocate Judge Kazen and I did, and that's the bell. We will turn to questions. Good job.
Wow, that was great timing. When does that happen in life? So we're going to have a few minutes now for questions. So please approach the microphone so everyone can hear, especially those watching online. And we will, I'm sure, have online questions come in. So we'll work those in as well through Molly here in the front. Yes, sir.
Can you hear me? Good? So quick question. So I understand you were talking about having or had addressed the issue that most of these programs are likely going to take a longer amount of time working with these individuals outside of the normal, had I just pled guilty, here's, I'm already done and I'm out the door, right? Since it moves to the probate side of things, is there something that would allow, or are they already allowed to expunge the original arrest so that they don't keep building up that background of I'm continuing to get arrested because I decomp and I'm back in and things like that? Or is that a permanent, it's great the work that you're doing, and again, it's taking a lot longer than had they just pled guilty. So is there another benefit to having their record expunged for the original arrest?
So I'm going to let Professor Shannon on the tail end of that answer it. There's many different things. First of all, when it comes over to the probate courts, this probably works better for county courts that can do, but they have a criminal docket and they have a probate docket because they can move them over to treatment. Typically, the individuals going through AOT are individuals that we see over and over and over and over again. So what's my motivation? I don't want to stay in jail is a good one. I don't want a conviction is a good one. And I'm accessing the same treatment I would have accessed anyway had I not been taken to jail. Last example, I can go down to Dallas, down to their cattle district, get drunk, kick over a pot. I'll probably go to county jail. I'll probably spend 3 days credit for time served and walk out with a conviction. From a defense perspective, great job. I was a criminal defense attorney for a long time. But from a health perspective, from a life perspective, did I really do that good of a job? Because more likely than not, I'm going to wind up in jail. I'm going to wind up in jail without a bond. I'm going to be found incompetent. And most people don't realize there are as we speak today, there are 2,000 individuals across the state of Texas sitting in jail waiting for one of those very few beds, and the wait is often a year and a half long. You ask me whether I want to take treatment on the outside or sit in the jail and get my charges dismissed? It's kind of a no-brainer for me. So, but I get what you're saying, because the criminal defense attorney means, say, just plead guilty for credit for time served and you're out of here. Assuming you're competent, assuming you're not mentally ill, assuming you're not in crisis. And more importantly, we also have to remember that AOT, like I started off with, is just a tool. And it helps in a significant number of people who are reading a significant number of resources who are living an other than healthy life. It is not the answer to everything. And there are going to be some people who will never be in an AOT program. And they'll say, heck, I'll take my credit. I'm not going to listen to some judge tell me I need treatment. I'm out of here.
And I just add, when, at least with the 1622C5 diversion where the charges remain pending, when you get to that stage, one of the other options for the court is to order a competency evaluation, and you proceed down the competency path, which could take much longer, right? Than, because if there's concern they're not competent, they can't plead at that point either, at least not constitutionally. So this is a decision that could be made by the court at that early stage, rather than going the competency path. Is, you figure the person's probably meets civil commitment criteria, we're going to go this other path if the AOT court is ready to receive them. Now, back to the expungement question, I don't recall exactly the nuances from memory. There were some changes to that 2 sessions ago to at least increase the opportunity for low-level offenses, first offenses, but it's not broad across the spectrum.
Because I'm curious, because these are the kind of people who are still going to need those community-based services.
Yes.
With the conviction on their record, they're essentially, or
Yeah,
the
but
charges on their record.
Well, it'd be dismissed
They're not getting convictions.
at the end of the program.
Correct, but within the system, you can still see.
I think he's talking about arrests themselves.
Correct.
Yeah.
Right, yeah. And, to some extent, again, that's where I say AOT is a great tool to help a lot of people, but it's not the answer to everything.
Thank you. Speaker on the west mic.
Thank you. And again, just to provide a counterbalance, the continuity of care rule in Texas requires that every LMHA have someone in the hospitals to ensure that when somebody is discharged, that connection to the local mental health authority and services are made. That doesn't happen.
I agree.
Let's be clear. This is a lack of funding services and implementation of what we already have on the books. AOT, at a very high cost, is plugging that gap. My question is, why aren't we funding services on the front end, which are preventive, upstream, and don't end up with people in jail? These, you say that gap is the problem. Let's address the gap. And so we're pushing AOT, which, I appreciate all of y'all's experience and what you're sharing, but what I'm hearing is someone who's been in and out of the system, i.e. trauma after trauma after trauma after trauma, which is complex trauma. This person is not going to come in for services. Why? Because they've been hurt by that system that says that they're there to help them. If we can actually have people, when they get identified, provide the wraparound services that they get under a court order, they wouldn't be the people going in and out of services. They would be the people with a team in their corner. A lot of these services end up having supportive housing. I have to offend to get those services. One of the things we're missing here is that these are treatment failures that are ending up in the court. It's not the person's failure. It's the treatment failure. We are not funding our system. We're not providing recovery-based services. We would probably all be up in arms if we wanted to pass a piece of legislation that says that if you refuse treatment for your cancer, you're going to end up in a court.
May I answer that for a second, please? So it's important that we realize we're not on opposite ends. And sometimes in Texas, we tend to debate the front end versus the back end. We shouldn't. I absolutely agree with you. Everybody here, if I could quadruple front end treatment, we would be able to help a lot more people than if you quadrupled alone, than if you quadrupled back end treatment alone. But if you understand that it's a continuum of issue, that for many people, the people who, even if we had the treatment on the front end, would be coming back over and over again. And if you actually look at AOT as a tool in that continuum, and it is not at a horrendous cost, it's the same people who would be accessing treatment. All the judge and the AOT court order does is give it the impetus for the person to try to succeed a little longer than they would have, and it usually works that way, without somebody giving them the impetus to succeed. I think what often happens in the debate between people who are against compelled treatment, it's not compelled treatment. It is for those, again, by your reaction, it's for those individuals, but again, it is for those individuals who, even if we had the cornucopia of services on the front end, which I think we should, would still not succeed on the back end, that there has to be some impetus for that category of individuals who don't want to access treatment, some motivator to get them there. I think too often
Thank
in
you,
this
Judge
debate,
Kazen.
we seem to be split, and we shouldn't be.
Thank you so much, and thank you for the passion in the room. It is wonderful. So we are out of time for this session, but again, the panelists will be available at the question and answer table outside, so we invite you to participate in that. Next, we're going to hear from our lived experience expert. We're going to hear from Eric Smith, and he is going to come and speak to us from a standpoint of how things can work out for the better. So let's thank this panel.